I don't think I can proceed on this termination action anyways. I mean, I don't think I can do that if it's solely on the basis of committing an assault on another resident. I don't feel comfortable with it. I got a guy here that's charged with a 4-year felony, and if he did it, I don't have any.
A landlord shows up to court ready to evict a tenant charged with felonious assault on another resident. The tenant, nowhere to be found. He's in the hospital. His sister shows up instead. And somehow, the rent got paid just in time. Classic last minute move. But here's the twist. The judge already saw this coming. He stayed the eviction himself because this man has a 4-year felony pending in circuit court. Now the question isn't just about rent, it's about rights, criminal charges, and whether this judge can even touch this case. Buckle up.
Granite Televalley versus Ronald Allen Bodges, 260001. Come on up here, ma'am. Good morning, Mr. Landman. Your appearance.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
Mr. Bodges' sister is shown up here. I'm not sure why. I'm going to at least ask her to identify herself. Come on up to the podium.
Oh.
That's the podium there. Your name?
Michelle Bogus.
Where is he?
He is in the hospital. I went up to the desk and gave them the paperwork from the doctor, went through the emergency room. He is going in long-term rehab. So all his rent is all paid up. There's a copy of that there as well. With her signing off on it and the receipts.
So, Mr. Landman, this is the one I was a little curious about. They started not only the termination action, but a non-payment action. If you'll bear with me, I think this is what happened is I stayed this case because this has to do with failure to comply with community rules. And he's charged with felonious assault. So I didn't per se stay it, but what I said is I don't think it's fair. He's got a felony pending, and I'm not going to have somebody in a civil case without a lawyer incriminate themselves. But in the meantime, your office did a non-payment rent case. I'm pretty sure, don't quote me, when I get rid of a case, I forget about it. But I'm pretty sure, unless your records will reveal differently, that I gave you guys a judgment with a writ date. And it sounds like Mr. Bodges has paid that now. You heard what his sister just said. I'm sorry, ma'am, your first name again? Michelle. So my inclination here is for us to double check on that. Jennifer, are you out there? Yeah, would you do me a favor?
Your Honor, the property manager is present and raising her hand, so she may be able to give us some insight too.
Okay, thank you. Wait 1 second, Ms. Bryant. Jennifer, would you check on that? I'm pretty certain that I'm right on that. Ms. Bryant, you can unmute and tell me your name.
Suzanne Bryant for Granite Televalley. Yes.
Is my recollection correct?
Right. He had a writ date of the 8th and he paid by the 8th. So it was all taken care of.
I don't think I can proceed on this termination action anyways. I mean, I don't think I can do that if it's solely on the basis of committing an assault on another resident. I don't feel comfortable with it. I got a guy here that's charged with a 4-year felony, and if he did it, I don't have any remorse for him, but I still have something to do here, and that is to protect people's rights, and I can't imagine me forcing somebody to go through with the hearing. So I can do one of two things for you. I can adjourn this again, but I'm not going to set a hearing date until there's a resolution of the felonious assault case in circuit court. So I'm inquiring whether or not you may be willing to dismiss this and refile when that issue is resolved. Ms. Bryant, you had your hand up again. I can't change my mind on this. I want you to understand I won't. But go ahead. What do you want to say?
Your Honor, if I may, before Ms. Bryant, firstly, which hospital is he in right now?
He's in the Heritage Hospital on Telegraph Road. When I came in, I went to the desk and they have all the paperwork that's notarized, signed by the doctors, all the receipts.
Who has it?
Pardon me?
Did you go to Heritage or did you bring the paperwork here?
I took them to Heritage, and then I came here.
I
this
know.
morning.
Where's the
Yeah.
paperwork?
Yeah,
Your
it's
Honor, it should be in your file. We did bring down a copy.
Yeah,
Oh,
I brought them.
so it just said he's admitted on April 12th and will remain inpatient until medically cleared.
Yes.
So did you want to say something else?
Your Honor, I do need to make a record on this.
And you're going to say why you
As the
dis-
court is aware, the standard in this particular
I
case
know.
is a civil standard, which is
I
weight
know.
of the evidence.
I know.
The problem that the concern that I have is I have a history, not with this particular individual, but in a different court, in a different case with a similar situation, that being a tenant that was charged with an assaultive crime. There was a delay of approximately 3 years from the date of the offense until the termination case was actually heard.
The same reason that I'm mentioning though, right?
But under no circumstances is my client going to dismiss the case and then turn around and have to file a new 30-day notice whenever these other proceedings are concluded. My recollection is that in this case there may also be a competency situation, and the last thing I want to see is this case delayed while we're waiting for the defendant to be competent to stand trial in the criminal case.
What do you want me to
also
do,
the
though,
possi-
Mr. Landman? Tell me what you want me to do. I can't
Well-
proceed.
I see two possibilities, Your Honor. Well, three possibilities. What we would prefer, obviously, is for a trial date to be scheduled. That not being an option, then there's two ways to go. We could do a conditional dismissal with the tenant agreeing to move out by a date certain. We're not able to do that today, obviously, because he's not here. The other option is to, again, adjourn and get a new date. And if the tenant is willing to vacate, we can get a conditional dismissal in before that date.
It doesn't, well, he's got to agree to a conditional
You
dismissal,
would,
right?
yes, that's correct. And obviously, you can't do it today because he's not here.
There is no way I can go ahead and proceed with the trial on this. I just am not comfortable with that. I'm not even sure I don't believe now I could be wrong. He just paid the money on a non-payment case. That signifies an intent that he has no intention of leaving.
Well, he's also required by statute to keep his rent current while the termination case is pending. And that's 600 MCLA 600.5779.
I get all that, but that tells me he doesn't want to leave. Right? I mean, if he wanted to leave, he would have not paid his rent and just left, right? So I'm pretty confident when he comes back here next time, he's going to tell us that he doesn't want to leave. I am not going forward with a trial on this without a resolution of the Wayne County Circuit Court action first. I'm just not comfortable with it. There's no way I'm doing that. That's not fair for me to do that. He might be not the best person in the country, but you know what? He has rights and I'm not going to violate them. So what am I supposed to do? Keep a landlord-tenant action open, like you say, for 8 months? I mean, I guess the Supreme Court is going to come down on me thinking I'm fooling around down here, but that isn't the case. And I can't enter a stay of this and have the time guidelines stop running, or I would. So I'm not quite sure what the answer is, but
I think he has a trial date. Currently, there's a trial date, I believe, in July, but I don't know what the competency ruling of the decision is going to be between now and then.
And that's probably going to get delayed because the competency exam staying everything else essentially. They're not pre-trying it. They're waiting for the report. I'll adjourn this 2 weeks to April the 27th. Jennifer, is that right?
That is correct, Your Honor.
At, what time? 8:30?
No, let's do 9:30, please.
Okay. 9:30. I'm just asking you guys to put yourselves in my position here. I would waive any filing fee. Obviously, if you agree to dismiss this, I can't do anything about the 30-day notice. Although maybe I can figure out something. At any rate, you guys come back and I'll see you on April 27th on that one, okay? And then you can
And Your
tell
Honor,
Mr.
in the
Bodgers-
meantime, if the court can, I don't know if the court has any information that's available to the court and obviously not available to me with respect to the status of the competency evaluation. I'm assuming that this gentleman has counsel in the criminal case, perhaps court appointed, but I would also expect that that case is at least moving forward to some degree, and that a competency evaluation would have taken place or would be scheduled rather than the case just sitting fallow.
No, I think the problem with the competency exams, I don't think you do a lot of criminal. The problem with those is that they get scheduled, especially for somebody who's not in custody a couple months down the road. And that's always the difficulty there. Now, he told me, I think it was just one of the last couple of times that the competency exam had been ordered. So maybe there was a delay in doing that. And,
Your Honor, Ms. Bryant has contributed and indicates that there is a competency exam scheduled for May 23rd.
right.
So maybe April 27th is not a great date to put this out. Maybe we put this out until after the competency exam.
Competency exam, by the time they get the report, it's going to be June the 10th. I want to think about this. I'm going to still keep it on for April 27th. You'll have other ones that day. I might dismiss this on my own. I don't know how I'm going to handle it. I'll think it through. Good luck. I mean, I can't do that really, but maybe I can come up with something that's creative. Have a good day. That's what I'm doing. Thank you.
The judge adjourns. No trial, no eviction. Just a creative solution nobody can name yet, while a felony assault charge sits in circuit court and a tenant stays housed. The judge is balancing rights against reality. But here's the moral question. When protecting one man's rights puts an entire community at risk, where does the judge's duty really lie? Do you think the judge made the right call, or did the system fail the victim here? Comment below, hit like, and subscribe for more real courtroom breakdowns.